Thank you very much, Konrad, for your kind introduction. And I'm really happy to be here. This is a wonderful week for me. So yesterday was my first day in classroom after 1.5 years. And this is my first conference in person after probably almost 2 years. But coming back to the time of the lockdown, there was one small advantage. As Professor Bock just referred to the question of outreach, I hope this will be continued, namely that some or even all of the proceedings of the Assembly of States Parties would continue to be streamed online. Because last year in December, during my course on international criminal law, I sent my whole group of students to watch Fatou Bensouda deliver her final report on 9 December 2020. And I'm coming back to what Professor Schäbers already referred to in his keynote today, the report delivered by former prosecutor Fatou Bensouda on the situation in Iraq, UK. You're all aware, she decided to close the preliminary examination without seeking authorization to initiate an investigation. So after 6 years of preliminary examination, and we are all aware that in 2014, the prosecutor had reopened this examination after her predecessor had previously found that the crimes committed by UK military personnel in Iraq would not meet the gravity threshold of the Rome Statute. So after 6 years of examination, the prosecutor concluded her examination with the following findings. First, there's a reasonable basis to believe that members of UK armed forces committed war crimes within the jurisdiction of the ICC against Iraqi civilians. This mainly in detention centers. The crimes include willful killing, murder, torture, inhuman, cruel treatment, outrages on personal dignity, and some cases of sexual violence, also including rape. Second, after an inadequate initial response to those crimes, the UK established domestic investigation mechanisms, namely the Iraq Historic Allegations Team and the Service Police Legacy Investigations, which henceforth I will call the domestic investigation mechanisms. They examined thousands of allegations for a time period of more than 10 years. And these domestic investigations did not result in one single prosecution. Third, despite the lack of prosecutions, let alone convictions, the ICC prosecutor did not conclude that UK authorities have been unwilling genuinely to carry out investigations and or prosecutions, or that decisions not to prosecute resulted from such unwillingness. I excuse myself for the bulky language, but that's the wording of Article 17 of the Rome Statute, in the negative that Fatou Bensouda used to not give the impression that she might actually say there was no unwillingness. She just did not find that there was no unwillingness. So in her assessment, the prosecutor partly relied on established jurisprudence on the principle of complementarity, but also, and this is for the first time, she developed a framework to evaluate the genuineness of domestic proceedings. And in my presentation today, I would like to question the result or the results of this final report, not necessarily with regard to the way the admissibility test was applied to the established facts, but rather whether the chosen standard of review is apt for the situation at hand. To this end, I will provide a quick overview over the jurisprudence on complementarity that was developed at the ICC. I will then outline how this test was applied in the situation in Iraq, and I will conclude with a critical assessment of the findings of the final report. Now, the jurisprudence on the admissibility test, including complementarity, of Article 17 origins in the very early case law of the ICC. You will all recall the strategy of the first prosecutor of the ICC to solicit so-called self-referrals. a practice that was not explicitly foreseen in the Rome Statute, but obviously is not in contravention to the wording of Article 13A. Thus, states were in a position to refer their own situation to the court. There are obvious advantages. States parties would be able to control the justice narrative, that they have brought their situation to the court for accountability. But also there's an advantage for the prosecutor, who can count on more openness from that state and maybe a better cooperation with that state in the proceedings. Now, different from the first assessment of the prosecutor, the ICC judges did not accept that a self-referral automatically would render cases admissible. The judges held that even cases that come from a self-referred situation must undergo at least a rudimentary admissibility evaluation. But in order not to demean self-referring states with a determination of unwilling or unable, and that's the only two possibilities that you find in Article 17, the ICC developed a two-step test to be applied to Article 17. First, the court would establish whether there was any activity at all on the national level, and only if the answer was affirmative, an assessment of the unwilling or unable criteria would be required. To do otherwise, that is the appeals chamber in the Katanga case, would be to put the cart before the horse. Because in case of inaction, the question of unwillingness or inability does not arise. Inaction on the part of a state having jurisdiction renders a case admissible before the court. Now, the point of reference for inactivity was a rather narrow one. According to the pretrial chamber in the Lubanga case, for a case to be inadmissible, the national proceedings in question must encompass both the person and the conduct, which is the subject of the case before the court. Person and conduct. I think it was also mentioned today in the morning already that at the time of this decision, Lubanga was held in custody in the DRC on charges of genocide. But the ICC found that since the charges, namely genocide on a national level, did not reference to any of the crimes charged before the court, which was the recruitment and use of child soldiers in armed conflict, the DRC was considered to be inactive with regards to the conduct charged before the court. So the defining elements are the individual and the person and the alleged conduct. There's little room for interpretation with regard to the same person part of the test. An argument brought forward by Kenya that persons in a similar hierarchical position than the person potentially accused before the ICC would satisfy the same person test was rejected by the ICC. The same conduct limb, on the other hand, produced varying points of reference. The early jurisprudence of the court understands the conduct to be incident specific, whereby an incident refers to a historical event defined in time and place in the course of which crimes within the jurisdiction of the court were allegedly committed by one or more persons. In the Ruto case, and this is a case in which Kenya contested the admissibility of the case, the appeals chamber introduced a qualifier. According to the chamber, for a case to be inadmissible, national investigations must cover the same individual and substantially the same conduct. So we have a qualification of the conduct part of the test, as alleged in the proceedings before the court. Although the ICC then returned again from conduct back to the incident-related assessment, the qualifier remained. And it leaves us with the issue of overlap or sameness of incidents that need to be compared. Unfortunately, the jurisprudence does not offer too much of a blueprint for this evaluation, and in particular, the required degree of overlap. So an evaluation would need to settle somewhere between identical cases that would impede further proceedings before the court and cases that deal with entirely different underlying incidents. And it will depend on the fact of the individual case, whether the conduct is considered to be substantially the same, or in other words, also by the ICC, sufficiently mirrors the one that the prosecutor is investigating. So to conclude, the admissibility jurisprudence was developed with a view to the specific needs of the instrument of self-referrals, introducing an additional assessment with regard to the activity or rather inactivity on the national level, with the idea to avoid a stigmatization of states that are willing to refer situations to the court. The point of reference, the overlapping conduct or incidents bears some flexibility, always with regards to the circumstances of the case, but it's notable that if you compare the early interpretations, Lubanga, Katanga, where you have a rather narrow point of reference, to later decisions where complementarity was partly contested, you see that the reference broadens in a way. So it's not seen one conduct, one person, identical conduct, but we have some leeway in this interpretation. Now, how would this jurisprudence translate to the evaluation of situations before the court? So far, we have only talked about individual cases. The Rome Statute offers some guidance in Article 53. And the prosecutor is, according to Article 53, and I will put this very bluntly, literally, and also from a civil law background, the prosecutor is obliged to initiate an investigation unless he or she determines that there's no reasonable basis to proceed. And to do so, in accordance to Article 53, the prosecutor needs to consider whether the information that is available provides a reasonable basis to believe that the crime within the jurisdiction of the court was committed. So that's our standard of proof, a reasonable basis to proceed. The prosecutor also needs to consider whether the case is or would be admissible, and whether there may be any circumstances that would render an investigation not in the interest of justice. So in other words, the prosecutor is required to assess the admissibility at the stage of formally initiating an investigation, so at the end of a preliminary examination. Given this very early stage of the proceedings, it seems at odds that Article 53 already refers to a case that is or would be admissible. In her policy paper on preliminary examinations, the former prosecutor points out that the office shall examine whether such national proceedings relate to potential cases. And this is also in line with the jurisprudence of the ICC, in particular with a decision in the Kenya situation that was rendered shortly before. I'm not sure whether the judge is in the room. I don't see him at the moment, but one of our participants participated in this decision of pretrial chamber 2 in the Kenya situation. So the requirement that the pretrial chamber set up was that potential cases should be defined by persons or groups of persons that are involved and that would likely be the focus of future investigations, and also the crimes within the jurisdiction that were allegedly committed during that incident. Now, this preliminary selection would not be binding upon the prosecutor, and he or she could come back to it if further evidence arises. But one aspect is quite interesting, I think, and you can also see this in general in the jurisprudence of the ICC, that chambers, the pretrial chamber, but also trial chambers, try to guide the prosecution towards a rather early conclusion of preliminary examinations and investigations. In particular, the first 9 years of the ICC, we had very rough examinations that were certainly not concluded when the investigations were initiated, and partly also not when there were applications for an arrest warrant. So you see in several decisions, inquiries by judges that certain investigative steps should be concluded. And this is probably one of those decisions. Now, I'm not going into detail with regards to another controversy that we have with regards to admissibility, and that is the judicial review of the admissibility evaluation of the prosecutor. When the prosecutor wants to initiate an investigation pro moto and does so, the pretrial chamber needs to authorize this investigation and has a judicial review function. If you read Article 15, where this review function is explained, you find references to the evidentiary standard, the reasonable basis to proceed. So the pretrial chamber also needs to be satisfied that there exists a reasonable basis to proceed. And the pretrial chamber also needs to be convinced that there is jurisdiction in the particular case or situation at that point in time. But it doesn't speak about admissibility. Such a review was initially claimed by the pretrial chambers, but recently in an appeals chamber judgment in the Afghanistan situation, this was renounced because obviously it's not particularly mentioned in the Rome Statute. It also makes, there's a different evaluation and reasoning, I think, behind a judicial review of the evidentiary standard and jurisdiction than of a rather subjective interpretation of possible potential admissibility of future cases. Now, let me turn to the question how the complementarity test was applied in this situation in Iraq. The prosecutor applied the two steps test, although there was obviously not a self-referral by the UK in that situation. The first step of the test, whether there were any activities on a national level, was answered in the affirmative. Given the available evidence, it is undeniable that investigations took place before different investigation mechanisms and over an extensive period of time. The area of overlap of incidents and conduct, or the sameness, is dealt with in a more rudimentary way. You remember the elegant solution of the national genocide and the international child soldiers charges. The final report in Iraq concludes that UK national investigation mechanisms appear to have examined the same body of incidents and categories of perpetrators that would likely form the focus of an investigation by the office of the prosecutor. Accordingly, the report could not conclude that the UK authorities remained inactive in relation to potential cases that the office would like to focus. So we do have overlap, we do have sameness, so the only way out that is left would be inability or unwillingness. Although if you already have investigations, there's not much room to argue inability. Now, this assessment would be almost convincing if the report did not alert to the fact that national investigation mechanisms appear to have centered on the role of physical perpetrators and their immediate supervisors. And if the report did not at least hint at a systematic lack of prosecutions of alleged war crimes in the UK. No policy, but yet a lack of clear guidance with a view, for instance, to interrogation techniques that were used in prisons in Iraq. While I would not call this a smoking gun, one wonders whether a formal investigation of the prosecutor at this ICC would not have produced further evidence up the chain of command and would have brought this into the light. Now, going into the merits of the complementarity test, the prosecutor leaves aside the question of inability and concentrates on the question of unwillingness and goes into a very detailed detailed analysis. In that, the prosecutor particularly relies on filtering criteria that were used by the national investigation mechanisms. And the criteria that were applied in decisions not to prosecute. And with respect to these decisions, and also keeping in mind that it is the primary role of the national criminal system to conduct such prosecution, the prosecutor found that the relevant standard of review would not be whether the prosecutor, him or herself, would have come to a different conclusion on the basis of the available evidence, but rather on a rather lower standard, whether the national decisions demonstrate an intent to shield a person from criminal responsibility. So the OTP report examines some of the individual cases, filtering mechanisms, decisions not to prosecute, also referring to difficulties in obtaining evidence years after the crimes took place. So we have heard this already. The prosecutor's analysis reads plausibly. It seems like a state-of-the-art execution interpretation of Article 17. But still, there remains some unease, in particular regarding some under-highlighted aspects. For instance, the lack of any criminal investigation of persons with command or superior authority, from military commanders to ministers. The role of the Attorney General and his possible impact in the independence of prosecutorial decisions. And most extraordinarily, the OTP does not treat the government's decision to shut down the national investigation mechanisms as amounting to an interference with the independence of that investigation. And there are clear tracks of a concerted campaign, media campaign, and also parliamentarians who had an interest to shut that down. So if we want to assess this final report, it's one of the clearest findings by any official body of the extent of UK abuses in Iraq. And this is in itself a success of the preliminary examination, even if the circumstances will not allow the situation to proceed to the investigation level. At the same time, the decision is disappointing, in particular under the light of the clear findings of the report. A very unfortunate result for the appearance of justice and claims of double standards that have just started to decline. A development that was due to Fatou Bensouda's small but persistent steps to test the jurisdiction of the ICC vis-à-vis powerful actors, states parties, as well as non-states parties. And I would like to refer to 4 factors that I believe contributed to this result. First, the nature of the preliminary examinations, which were kind of blown out of proportion by the first prosecutor of the ICC as a tool to engage in a political process with the state concerned. Second, and also depending on this first factor, the length of such extended preliminary examination, which produces also difficulties with regard to old evidence, historic evidence, and the general length of proceedings. Third, the standard of review, in particular the admissibility of a case approach to the situation level. This seems out of proportion for this very early stage of the proceedings that we are in at the end of a preliminary examination. And it also seems to exceed the evidentiary standard that is applicable at the time, namely a reasonable basis to proceed. And finally, the report focuses on genuineness, but leaves lacunae in the evaluation of structural unwillingness. And as one commentator writes, the OTP apparently fails to see the forest for the trees. It justifies individual decisions not to prosecute while not examining the overall political context and clear statements and actions of UK government. So just to come back to the title of my presentation of the complementarity test between self-referrals and contesting state, obviously the UK was not self-referring the situation. They were also not formally contesting the admissibility because it's not possible to challenge the admissibility before there's a formal investigation. But certainly in substance, partly publicly, partly behind doors, the UK was certainly a very strong contester, and this can also be read or left some traces in this preliminary examination and the final report. Thank you very much.